Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open. 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Jim Potts back on the air here. How are you today? Well, I got to tell you, at last, President Obama got it right. Yep, that's me. We're going to be a little political today, despite what my producer thinks or says on this one. We get calls from time to time because employers are upset because employees, when they leave, take certain information with them, with trade secrets and confidential information, etc. So they get very upset about that. And ordinarily, it's very, very difficult, to prove that in fact somebody took some additional information or took information that they should have left behind. You see this a lot with people working in sales, where they'll take our list, customer list, things of that nature. And on May 11th, actually, President Obama actually signed into law the Defend Trade Secrets Act of 2016. Now, normally is what we talk about as the employer-employee relationship per se. This is a little bit different only in terms of, about the trade secrets. But I think that this is good because it involves employees who actually leave the company and take things with them. Now, so what this does is that it creates a uniform federal cause of action for the misappropriation of trade secrets. Therefore, companies in particular who operate actually in more than one state can actually seek nationwide relief from the misappropriation of trade secrets. And it's not limited to that. You could be just in one state, you could just be in California. It doesn't make any difference where you are. But if you're in multiple states, it's a little bit better as well. And as what this does is that this misappropriation of trade secrets, sorry about that, folks, without regard to the differences in the state law. So what are we talking about? State law doesn't matter for the moment. We're talking strictly federal law, because it creates this federal cause of action and it grants access to the federal court without regard to the state of citizenship of the parties. That part is getting a little technical, but I just want you to understand it means that no matter where they are, they're not going to be able to take it from you. Now, number two, I want you to understand it does not circumvent the state laws regarding the enforceability of non-compete agreement. Now, look, some states have these agreements where the employee signs off that they're not going to compete with the employer. And it's normally for a specified amount of time. Now, California, non-competition agreements are against public policy, and therefore they're not enforceable. Other states, they are enforceable. So as what Obama is saying through this new law is that if the state law has a non-compete agreement and it's not enforceable, you're still not going to be able to enforce the non-compete agreement. But that won't negate, a cause of action for somebody taking trade secrets. So you're still going to be able to protect your trade secrets. It also doesn't preempt state law trade secret laws to the extent that they provide greater protections. So if the state has a greater trade secret law, the state law will apply. All right, let me make that clear. Now, this new law, the Trade Secrets Act of 2016, creates a mechanism for the civil seizure also of stolen trade secrets. That means that an employer now can actually go out and seize the information that the person may have taken. Now, they also say it has to be extraordinary circumstances, and whereby as a result of that, a federal court may order the civil seizure of property necessary to prevent the propagation or dissemination of the trade secret that is the subject of the action. Now, one of the preconditions of the seizure is that the person requesting it has not publicized the requested seizure. So you can't really say anything about it. I guess I mean, I'm not sure why that is, but you certainly you wouldn't want to do that anyway, because you wouldn't want to tip off the person who took it that you're coming to get it back. So, you have to kind of keep that under wraps. Now, I think it's huge that they can actually go out and seize this property to get it back, because ordinarily is what an employer would have to do when they suspect that a person has taken, this confidential information or trade secrets. You got to go through the civil litigation process, and that can be very lengthy. By the time you get through it, if you can even prove that the person took it, this could be months, maybe even a year or two down the road, and the damage will already have been done. Now, aside from the newly created civil seizure remedy, other more traditional remedies are also available. Look, you can also still get an injunction, which was something that you would be able to do before anyway. But again, when you get an injunction, you've got to go in and you've got to prove it. You got to spend a lot of money in order to have the representation from counsel to be able to go and get it. And then you could also get compensatory damages. Well, compensatory damages are your out-of-pocket damages, basically. So you'll be compensated for whatever it cost you to be able to retrieve the property. And obviously, attorney fees are a consideration as well. And then there's what they call exemplary damages, which is basically two times the rate of the compensatory damages. So if the compensatory damages are $2,000 just for the easy math, then you'd be able to collect $4,000 in exemplary damages. It's really just a formula that they use. Now, as I told you, the attorney fees are also that you can get. Yeah, that could be very expensive. But you got to also understand that you cannot bring a claim against somebody in bad faith. I would caution you that if you, in fact, only suspect that somebody has taken some type of trade secrets or, customer list, then, that's going to be problematic. And I'm going to tell you something. A lot of times that's what it is, because we get those calls and they'll turn around and say, well, we think that they took this or we think that they took that. You got to be able to show that, in fact, that they did take it. Now, look, the other side of the coin is you can't remove things from people's heads. If you've got a person that's worked for you for, I don't know, let's just say 3 or 4 years, 5 years, whatever the case may be, and, they know all of the customers by names, and in their head they got the phone numbers, and they basically know where they are. That's when it gets a little dicey for you, because unless you prove that they physically picked up something and took it, or these days downloading things, putting it on a flash drive, and technology is probably creating a nightmare for some of this as well. Back in the day, it was the old roller card index, where somebody could turn around and take the Rolodex, and they had all the contacts and all of the information, and then it moved to computers where you could print things out, take the customer list that way. And, these days with technology, even when a person is already aware that they're leaving, a lot of times these people already have what they're going to take, before they even give notice. So sometimes the employer runs around trying to prevent it. It's probably already gone. So that's why, in my opinion, I think is what the employers need to do based upon this new act here, is create a trade secret agreement and have them sign off on it when they first come to work, that they understand that if they remove anything, they could be subject to either federal, civil penalties, etc., or state. Now, we have those policies already as part of the employee handbook. So some of that's already included in some employees' handbooks. If you don't have that in yours, it's really something that you need to consider. The end result is improving damages. To me, that's always going to be the issue. How do you prove how you've been damaged as a result of your allegation that somebody's actually taken a customer list? Is it that all of a sudden all your customers are disappearing? How do you prove it, the reason why they left, without dragging customers into the courtroom? Now, if the customer's already gone, then you probably don't care about that, but the reality is, you're never going to get them back as a customer once you drag them into the courtroom. So proving the damages sometimes is speculative, and you're not going to probably be able to get away with speculative damages. So let's put this in its proper perspective. When Obama signed this into law, why did he sign it into law? Well, because, he's been getting blasted on the fact that he's got, no loyalty or no sense of responsibility toward employers. And now we're in a heated presidential race between the Democrats and the Republicans. And so maybe this is just a ploy to show that, okay, I'm going to be doing something for businesses, and here it is. But the practical part of this, although I'm glad that he did this, it still gives employers at least something that they can use, even if it's a bluff mechanism, for people to realize that they can't just take the trade secrets away from the employer. So from that perspective, I would say it's something that we can at least utilize. How much of this you're going to be able actually to collect on, only time will tell at this point. If you can get somebody good that really goes after the person and you can really prove those damages, then yeah, by golly, this could work. All right. So at any rate, there was a shout out to President Obama. I don't do that too often. For all of those liberals out there that have figured out that, hey, is this guy a conservative? Oh, I didn't say that because I got to watch out for my producer again. She doesn't like that kind of stuff. But at least there's one that's in our favor this year from President Obama. All right, with that last comment, it's time to close out this segment. But let me remind you can hear us on Facebook at Listen Up or subscribe to us on iTunes. Just search for Listen Up with Jim Potts. And as a reminder, we take calls every third Friday. You can call 855-4J-POTS or 855-457-6887 and call us between roughly 9:45 and 10:45, and pretty much you're going to reach us. Or you can email us at listenup@jameswilliampottsllc.com. Okay, I'm Jim Potts. I will continue to fight the fight, and thanks for listening.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@jameswilliampottsllc.com. Until next time, make it a great week.